Hello everybody, Puyan Darian here, back for another exciting immigration topic. Today we're going to discuss a slightly different topic. It's going to be about family preference category. Specifically, whether or not the spouses and children of permanent residents are immediately available to adjust their status to permanent residence. For those of you who are not new to this channel, you may recall from other videos where I indicate that immediate relatives, and I define that phrase very specifically, immediate relatives of US citizens are generally eligible to adjust status to permanent residence in the United States. Today I want to expand that statement very generally to include spouses and children of permanent residents. Not just US citizens, spouses and children of permanent residents today may be eligible to immediately adjust status. And the reason for that is because the visa chart, the visa category availability for that category is current. I'm looking at the chart in front of me. This is the visa bulletin for September 2021, and it indicates that category F2A, which is spouses and children of permanent residents, is current. What does that mean? So if the spouse of a permanent resident enters the United States on, let's say, a tourist visa, and that spouse decides that they want to adjust status to permanent residence while they are in their duration of stay on their tourist visa, they may be eligible to do so. Before this category became current, the spouse would have to file a family petition, I-130, go back to their native country, and then consular process back into the US. Temporarily, at least for the time being, there may be another option available. Okay, so a couple caveats. As you know, nothing I say in YouTube videos is legal advice, so don't act on it without speaking with me during a consultation first. With that said, this category is current today. And by today, I mean like September 2021 today. It may be current when you watch this video too. In fact, it's been current. And what I mean by current is spouses and children of residents have been eligible to adjust status for at least the last year. But you should not expect this to continue in the future. By the time you view this video, it may still be current. You should speak with me before you take any action on this. The other two things I do want to mention. Previously, I've indicated that unauthorized employment and unlawful presence generally will not affect the spouse of a US citizen who's applying for permanent residence. Those two grounds of inadmissibility will certainly affect the spouse of a permanent resident. All those grounds that are waived for spouses of US citizens are not waived for these preference categories. So that's something very important to keep in mind. You cannot overstay your visa. You can never have unauthorized employment. If you have either of those things, you should speak with an immigration attorney before you do anything. This is all really wonderful news, but please be careful. If you are not eligible to adjust status and you try to adjust status, the consequences are extremely severe and may not be fixable in some situations, especially when your spouse is a permanent resident. If you have questions about this, if your spouse is a permanent resident or you're a permanent resident and you have questions about bringing your immigrant spouse over here, please call or text or book a consultation online through my website. We're always here to assist you.